Welcome to educator.com. Today we're going to go over amendments 11 through 19. So these are the 9 amendments after the Bill of Rights. So let's dive right into the material here. All right, amendment number 11. So this is a lesson overview. I'm just going to briefly describe what these amendments are, and then I'll go a little bit more in depth into them. So let's go over Amendment 11 here. What is Amendment 11? What it does, it restricts lawsuits against states. Amendment 12, the president and vice president now have a separate election. The 13th Amendment abolished slavery. The 14th Amendment, it's the rights of citizenship and due process. Amendment 15 is the right to vote for blacks. Amendment 16 authorizes the income tax. Amendment 17 is a direct election of senators. Amendment 18 is a prohibition amendment. And Amendment 19 is women's suffrage. So in each of these amendments, I'll try to give you a little historical background. And again, the whole goal here, I want to prep you for this AP government exam as much as possible. So at the bare minimum, I'd like for you to be able to memorize amendments 1 through 27. And again, it's not a great legal knowledge that you're going to have to be able to memorize, but just like that the 15th Amendment deals with the blacks' right to vote, or the 17th Amendment deals with direct election of senators. And again, any simple or silly mnemonic that can help you out, I'm not beneath using that technique to get you that 5 on the AP government exam that you deserve. So let's get right into this Amendment 16 here. So what I've done is I've written verbatim, sometimes entire amendments, sometimes just 1 or 2 sections, and then go over what it says, and if it's how that information, how that amendment might come up on the AP exam here. The judicial power of the United States, shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. So this was ratified on February 7th, 1795. Basically, what it said is that individuals from one state are prohibited from suing another state. So if you're a resident of California, you are not permitted to sue the state of Massachusetts, for example. So the 11th Amendment addresses that. However, states, however, are not immune from lawsuits brought by its own citizens. And so there's this, this idea, this protection that the Constitution wanted to give to states from being sued by members of another state. But again, there's no immunity given to a state from its own residents. And definitely people have sued the state that they have lived in here. Amendment 12 here. So again, Amendment 11, it's good to know what it is, but you're not going to see a whole lot of emphasis on Amendment number 11 on the AP exam here. Amendment 12, actually, there's a theme I want you to be able to come across. So not only do you want to know what it says, but kind of the background behind it. I think, honestly, this is really interesting development on how the Founding Fathers didn't anticipate something, and they corrected it by amending the Constitution here. So this amendment actually provides for a separate election for president and vice president. And this was ratified on June 15th, 1804. Give you a little background here. In 1796, John Adams, who was a Federalist, so let's go ahead and use a blue underline right here. So John Adams was a Federalist, was elected president. Thomas Jefferson, let's use a different color here, was a Democratic Republican. He was elected as vice president. So you have 2 individuals of different political parties. Now that in this day and age, that actually might seem very strange, but keep in mind, back then there was no such thing as political parties. Kind of interesting note though, in the year 2000, or in 2004, when George Bush was running for re-election against John Kerry, there was actually, a lot of serious speculation that John Kerry was going to ask John McCain to be his running mate, and if he was willing to do that, if John McCain was willing to be on the ticket with John Kerry, he would have accepted. You would have had a Democrat and a Republican on the ticket against George Bush. But, John McCain didn't want to betray his party, and he eventually won the presidential nomination for his party in 2008. He lost to Barack Obama, but there is precedence for a president and a vice president to be possibly of a different party. Again, it also happened in 1864 when Lincoln was reelected. He actually had a Democrat vice presidential candidate in Andrew Johnson. But the first election after George Washington, one of the things the founding fathers didn't realize is that there would be this rise of political parties. So what ended up happening was that rather than the president and vice president being two of the most qualified people, it became pretty apparent that they probably had to belong in the same political party. And so in 1800, you had a different problem. So in the first, the president and vice president being opposing parties, well, you probably didn't see Thomas Jefferson having a lot of official duties in the Adams administration. Well, in 1800, Thomas Jefferson and Aaron Burr, they were running together. They tied for 73 votes, so the vote went to the House to break the tie. And as we know, in the House of Representatives, when there's a tie, each state they get one vote for president. And again, it was the old Congress that was voting, right? And so you had a Federalist Congress, and they were trying to determine who to elect as president, either Thomas Jefferson or Aaron Burr. Again, the Democrat Republicans, they understood that this problem might arise, but they couldn't execute. They wanted to get Thomas Jefferson 73 votes and Aaron Burr 72 votes, but it didn't work out here. So finally, on the 36th ballot, the presidency went to Jefferson. As Alexander Hamilton remarked, Jefferson was by far not so dangerous a man as Burr. So even though clearly the Democrat Republicans were intending for Jefferson to be the president, the Federalists, they were playing by the books, and the Federalists were they couldn't get a majority, they couldn't get they couldn't get a consensus, and it took 36 ballots until they finally conceded that Jefferson would be the less dangerous individual to serve in the presidency. So again, the takeaway from what the 12th Amendment is that the rise of political parties necessitated this change in the Constitution, as the founding fathers did not foresee this being a problem. George Washington, even though he probably aligned more with the Federalists, he never officially declared a political party. And again, a good mnemonic to use is the 12th Amendment made it so that you have a 1 and you have a number 2 running for president. So you have a 1-2, 1-2 punch in the presidency. And one interesting side note that you might find as factually interesting, at least I do, the president and vice president cannot hail from the same state. So one of the things that Dick Cheney had to do when he was the vice presidential running mate for George W. Bush was that he was currently resident of Texas at the time, and George Bush also from Texas. So Dick Cheney re-registered, and he declared his residency as being Wyoming, and so you had 2 individuals from different states running for the presidency, and that was okay. So Amendment 13. So Amendment 13 is very straightforward. This is something in U.S. history. If you took AP U.S. history or even a regular history class, you're probably gonna have encountered this here. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the parties shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. So anywhere within the U.S. or any territories, slavery is not permitted. And again, slavery being defined as you have not been convicted of a crime. If you've been convicted of a crime, you can't argue in the Supreme Court, well, this is slavery because I'm spending time in prison. Well, if you've been convicted, you serve your time, and that's absolutely permitted. So this was ratified on January 31st, 1865. If you've ever seen the movie Lincoln with Daniel Day-Lewis, Lincoln's effort to guide this legislation through Congress, that was the focal point of the movie, basically. If you want to ruin the movie, you have to watch the movie to see what actually happened and if if Congress was able to pass the 13th Amendment. But this includes peonage, which is debt servitude. So even if you owe someone tons of money, they can't forcibly enslave you because of debt that you owe. It includes involuntary servitude or any type of forced labor here. Again, this is rarely cited as amendment, in court cases. You don't have a whole lot of modern issues. It's very straightforward. You can't enslave. Any slavery is not permitted in the United States. So nothing too controversial. It was intended to basically ban slavery. Now again, if we repealed this amendment, would there be a lot of slavery? Probably not. But what it would do is some people might be able to make the case that it's not part of the Constitution anymore. So definitely something that would never be repealed in the Constitution. And again, there might be legal ramifications as a result. Okay, Amendment 14. This is probably the most often used amendment of the 9 amendments. So make sure you pay attention and you get this right, because this is actually considered part of the Bill of Rights, even though it's the 14th Amendment here. So Section 1 states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And that includes individuals that are born whose parents are not citizens. So if you are born in the United States, you are a citizen of the United States here. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, which is an identical passage, except rather than the state, the federal government, this is found in the 5th Amendment. Again, this is what's known as the Due Process Clause, and that's going to be very significant in citing future court cases. Nor deny any person within its jurisdiction the equal protection of law. So this is the Equal Protections Clause, and this was ratified July of 1868 during the Reconstruction era of the United States history. Okay, so what are the 4 clauses of Amendment 14 here? Well, the first one is that the state and federal citizenship for all persons, regardless of race, both born and naturalized in the United States, was reaffirmed. So again, it gave the sense of what citizenship is. Now, notice that women weren't included in here, and that was one of the considerations when putting the amendment. If women should be considered citizens, it didn't say women can't be considered citizens, but women weren't necessarily given the rights to citizenship or with the 15th Amendment voting. So this applied to generally men here. No state would be allowed to abridge the privileges and immunities of citizens. And no person would be allowed to be deprived of life, liberty, or property without due process of law. Again, this is the huge. So again, if you have a takeaway of, what is the 14th Amendment? Yes, it gave blacks the rights of citizenships, but that's more of a U.S. history perspective. If you don't look at a government perspective, it gave individuals due process of law, and it prevented states from denying due process of law. So what this has allowed courts to do is it's allowed the courts to apply to the states things that are in the Bill of Rights. And it does this in a piecemeal fashion. What the courts have not done is said, okay, now the 14th Amendment is passed, so all of the Bill of Rights apply to the to the states as well through the 14th Amendment. What they have done is in individual case by case, where it is appropriate, they've taken a piecemeal fashion and have incorporated the Bill of Rights to apply to the states individually rather than a wholesale incorporation of the Bill of Rights. And according to Citizens United versus Federal Election Commission, this was a court case in 2010. And again, there's a lot of people, including President Obama, that disagreed with this. Corporations are affirmed as people. So the idea is that individuals are considered, corporations because they're a composition of people. They have this right of free speech. And so in terms of an individual being able to make a documentary against a presidential candidate, even if it's right before the election, theoretically that person or that corporation has the right to fund that. So again, is this the right interpretation? Again, the majority of the Supreme Court sided with this idea that corporations are people, and you have 4 angry dissenters that absolutely believe that corporations are not considered people. And so again, the meaning of what what is or what isn't part of the Constitution, it's going to be dependent on what 9 men think, and that's the Supreme Court. And finally, the last clause of Amendment 14 is that no person could be denied equal protection of the laws. So let's go to Amendment 15 here. So Amendment 15 is the following here: the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude here. And this was ratified in February 1870 here. So again, this amendment gave blacks the right to vote, and it included, based on race, color, or previous condition of servitude. Again, what was omitted was there was no right to vote based on gender. Again, this was something that was thrown about at the time, but again, this was amendment specifically to give blacks the right to vote. However, in the late 19th century, the right to vote was narrowly interpreted by the Supreme Court. So this right to vote, when states would make certain laws, the Supreme Court basically allowed these loopholes that for all intents and purposes limited blacks the ability to vote. So they didn't directly say, okay, well, this is okay, but there's all these loopholes that states took advantage of to basically deny voting rights to blacks. And so the ways that they did this over the course of the late 19th century and into the 20th century were that, blacks faced literacy tests, poll taxes. So literacy tests would be, read these extremely difficult documents and be able to understand what they're saying. Poll taxes, so it's another way to prevent individuals from voting. Poll taxes that required monetary payments to vote. While whites were exempted by grandfather clauses. Okay, what grandfather clauses, again, they were not meant to necessarily, they're clearly there to prevent blacks from voting, but these laws that were prohibited, where maybe poor whites that couldn't vote because they couldn't pass a literacy test. Well, these grandfather clauses, because their family voted, they're exempted for certain rules. So it clearly was a system of discrimination. But again, the Supreme Court, they didn't step in. They didn't interpret it as being something that was broadly interpreted. So states could come up with tricky ways to try to prevent blacks from voting, and that's exactly what they were able to do in the years following its passage. In addition to these tactics here, the Ku Klux Klan intimidated blacks from participating. So not only were there literacy tests, poll taxes, and grandfather clauses, you had the threat of physical violence if you voted. So in the 20th century, the Supreme Court decisions and the passage of the Voting Rights Act of 1965 here, served to increase political participation with blacks here. One question I remember being on a past AP exam was the passage of what increased the participation of blacks in the political process here. And the answer here is the Voting Rights Act of 1965. And basically, in areas of discrimination, the voting methods that the states used had to be cleared by the federal government. So this was one way of ensuring that states could not prevent the significant chunk of the population from voting. Okay, Amendment 16 here is the following: the Congress shall have power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. So this was ratified in February 1913 here. February 1913, and the 17th Amendment. So a good mnemonic to remember the 17th or I'm sorry, the 16th Amendment. A good mnemonic is that when you're 16, so if you're watching this and you're 16, 16 is usually the age where you're permitted to work, and obviously you can work younger than that, but most students get a permit to work at age 16. You can work as long as you're at least 16 years old. And so when you work, one of the rites of passage of becoming an adult in society, well, you also pay taxes. So at age 16, you work and you also pay taxes. So you think of the age you begin working. I'm going to work at 16. I'm also going to pay taxes, right? Well, until 1913, the primary source of income was through tariffs and excise taxes. So they were the primary source of federal government revenue. Today, the primary source of revenue is individual income taxes. But again, back then, the way the Constitution was worded, a lot of people would have seen as being unconstitutional a direct tax on income, because they had the power to lay and collect taxes on income from whatever source derived without apportionment among the several states. So the 16th Amendment was a way to directly take away money from the people here. So what the 16th Amendment did, it allowed for a direct income tax permitted by the Constitution. Now again, there are some constitutional scholars that will argue that the right to tax is already existed in the Constitution, but again, matter of interpretation. So basically, the government has the right to tax your income. And actually, what's kind of interesting is that the whole idea of the constitutionality of healthcare, can the government mandate healthcare? Is it within their scope? Justice John Roberts, a conservative, actually sided with the liberal justices, but rather than saying that it was constitutional for the government to mandate healthcare, John Roberts, a conservative justice, argued that the government has a right to tax, and therefore it has a right to, tax individuals if they don't get health care. Okay, so basically the government has a right to tax. However, Wesley Snipes might disagree with the common interpretation with this amendment. If you're not sure who Wesley Snipes is or why I'm mentioning him, you might want to do a little research on Google. He was advised by his tax advisor and accountant that according to the Constitution, he didn't have to pay income taxes. Well, I guess he didn't. And he also served, a couple years in federal prison for tax evasion. I think the IRS claimed that he made, then they documented that he made about, $30 million over a period of 5 years. So if you don't pay taxes on that, chances are the government is going to come after you. Okay, Amendment 17. The Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. So the change being that they're elected by the people and not by the state legislatures anymore. The electors in each state shall have the qualification requisite for electors of most numerous branch of the state legislatures. Okay, so this was ratified in May 1913. So again, previously, state legislatures selected senators, and some objected to seats being bought by the rich. So the idea is that, it's not fair. This person became a senator because he wielded a lot of influence and the state legislatures were picking. So a lot of people said this is not a fair way. And so the 17th Amendment is kind of like one of the progressive amendments that people just saw as a way of changing the way, to make more direct political participation available. So state legislatures have the power to grant the governor the right to appoint senators if there is a vacancy. So it's the state legislatures that decide whether there's going to be a special election or whether the governor can appoint a new senator. And if you know anything about politics, when you give that power to give a very high-profile seat to an individual without an election, then there's also going to be a level of corruption, right? Corruption is possible, and chances are some people might be guilty. And in this case, the governor of Illinois, Governor Rod Blagojevich, he actually began serving a 14-year corruption sentence for attempting to sell Obama's vacated seat in 2008. So in the year 2012 or 2013, I believe, Blagojevich actually began his time in a federal penitentiary for trying to sell President Obama's vacated Senate seat. There are a lot of different people that were linked to these rumors. Jesse Jackson Jr., he wasn't charged, but a lot of names were linked to the idea of buying this Senate seat. And so there's some people that say, let's repeal or modify this amendment to take away the privilege of the governor of appointing a vacated Senate seat. But there's a lot of things that have to take place for an amendment to be passed, and this is probably not on the top priority list. Silly mnemonic that I would use is, you have the 17th Amendment deals with senators. Well, senators serve a term of 6 years, right? And the difference between 1 and 7 is 6. There's a 6-year gap. So from year 1 to year 7, a senator serves a 6-year term. So the 17th Amendment deals with direct election of senators. Okay, Amendment 18. Amendment 18, it's pretty simple here, but Section 1 says that after 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within, the importation thereof into, or the exportation thereof from the United States and all the territories subject to this jurisdiction thereof for beverage purposes is hereby prohibited. And so this was ratified in January in 1919. Now keep in mind, it actually did the following here. It prohibited the manufacture, the sale, the transportation, the importation, and the exportation of alcohol. What it did not do, it did not prohibit the consumption of. So if you were consuming it, technically you weren't breaking a law, and that was generally understood. So it did not prohibit consumption of alcohol, but it did ban its sale and distribution. So the problem with that is that the courts were overwhelmed with cases and organized crime increased. For example, I'm sure Al Capone. He made a huge profit because of the illegality of alcohol, and eventually the federal government they were able to convict him of income tax evasion because how did he make so much money? Never reported. So under Amendment 16, which income tax was legal, Al Capone went to prison not because of murder, not because of anything other than his failure to report income taxes. So ultimately, the amendment was repealed through the 21st Amendment. Okay. Now, again, a silly mnemonic is that think about it this way. So chances are if you're watching this, you're in high school. So maybe you're 18 right now, maybe you're 17. But think of it this way. At age 18, you think you're an adult. You think you're all grown up. But guess what? You can't drink, right? I mean, I guess you could, but you can't legally purchase alcohol in most states. So at age 18, you can't drink. So at age 18, just like you think you can drink alcohol, but you can't. It prohibits alcohol, the Amendment 18, but 21 you can. And 21 actually repeals the 18th Amendment. So at age 21, you can drink, and that repeals the 18th Amendment. And finally, Amendment 19 here. The rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation. That is the entirety of Amendment 19. Very simple here. This was ratified in August 1920. Again, another one of the progressive amendments here. It did not give women the right to vote. So, yes, it is the right to vote, but the article does not grant the power of voting. What it does, but rather it prohibited the federal or state government from denying the right to vote. Again, the way things are worded, again, this is dealing with law and the law of the land. So you have to be, the writers of these amendments have to be very careful how it's worded, because the way it's worded is going to have a ripple effect on the legal system, right? So to give you an idea, votes had been granted in the Wyoming, Utah, and Washington territories. So the trend mostly in the western states with a lot of these freedom, a lot of these territories where there's no habit of voting, women were already given the right to vote, but you can't say the same in some of the other states. So this 19th Amendment basically made it so that states couldn't deny women from voting, right? So the idea that women were able to vote if the states granted women the authority, but they could also prohibit women from voting as well. So this amendment took away the possibility of women being prevented from voting. And again, the argument that the 14th and 15th Amendment had already granted women suffrage was rejected, that the 14th and 15th Amendment narrowly applied to not gender, but race rather. So the idea is that the 19th Amendment was necessary to set in stone, to set in place the idea that women had the right to vote. And again, a silly mnemonic, again, actually a student came up with this, again, kind of silly, but if it helps you memorize the 19th Amendment, then more power to you here. Here's a quiz question. You know, how many babies do women tend to have with a pregnancy? The answer is obviously 1. Well, how many months is a pregnancy? And the common mainstream answer, although technically, you know, some women experience longer than this, is 9 months. So a woman has one vote, or a woman has 1 baby in 9 months, and therefore the 19th Amendment gives women the right to vote. Again, technically not a presidency, but a pregnancy is roughly 40 weeks, which is closer to 10 months. But for all intents and purposes, you know, 1 baby, 9 months, 19th Amendment, you have women's suffrage. Okay, so example number 1. So which constitutional amendment allows for direct election of senators? All right, so let's go down this list and figure it out here. So 13th Amendment deals with slavery. Okay, 14th Amendment deals with citizenship. And again, I'm gonna put the term due process here, because that, even though it's meant to give black citizenship primarily, it's been really, you know, the 14th Amendment is actually part of the Bill of Rights here. Even though it wasn't part of the original Bill of Rights, now it's, you know, states cannot deny due process, so it's incorporated a lot of the Bill of Rights to the states. 15th Amendment deals with voting, so that is incorrect as well. 16th Amendment deals with income taxes. 17th Amendment allows for direct election of senators. That is absolutely the correct answer. Bingo. Okay, example number 2. Which amendment was the only amendment ever to be repealed by another amendment? And again, you know, the 18th Amendment, you turn 18, you think you can drink, but you can't. But the 21st Amendment repealed the 18th Amendment. So the answer is the 18th Amendment here. Yeah. So again, I don't have to go over the previous amendments. This has to do with citizenship, voting, income tax, and direct election of senators. So 18th Amendment, you think you're an adult at age 18, but you can't legally purchase alcohol. Okay, example number 3. What necessitated the passage of the 12th Amendment here? So again, keep in mind the presidential election system. It was designed to have the most qualified man be president and the second most qualified man to be vice president. But this was before the emergence of political parties. So the correct answer is the emergence of political parties. So again, you can figure it out and then see which answer most closely resembles what you think as being the correct answer here. Lack of state powers, you know, that has really nothing to do with the 12th Amendment. Okay, the rise of political parties. So that's the answer I'm going with here, but let's see why the others are wrong. Increasing political participation of women. Again, women generally did not have the right to vote here. The need to establish racial equality. Again, the 13th, 14th, and 15th Amendment, maybe that would be a correct answer, but not the 12th Amendment. The inability for the government to tax its citizens. That was the 16th Amendment. So, again, the rise of political parties here. This is, again, you don't want to, I'm not going to go out on a limb and say this for sure is going to be on the AP exam, but a common theme is going to be, you know, where in the Constitution is political parties mentioned. And basically the idea is that the rise of political parties is more of a modern invention, something that happened as a result of natural men being, wanting to hold power. And so there's nothing in the Constitution that established political parties. It was simply something that came up as a result of tradition, out of more necessity to try to preserve political power within a certain group. And it became an easy way for voters to identify with certain values. So there's nothing in the Constitution. The Founding Fathers, you can argue that they never intended for the rise of political parties. At the same time, James Madison, who was one of the Founding Fathers, ended up becoming, the leader of his political party and therefore president. Yeah, it was not necessarily the intention of the Founding Fathers, but it developed as a result, and the Constitution made changes to reflect the needs of the democracy. The final example here, what clause to the 14th Amendment has been used to apply the Bill of Rights to the states? And this is a big takeaway I want you to have from this amendment, is it the Citizenship Clause? So yes, it is in there. But that does not, it is narrowly interpreted to apply, to citizenship. So that's not the clause that applies the Bill of Rights to the states. Equal Rights Clause, again, it is in there, but it's not going to be what's applied to the Bill of Rights. Double Jeopardy Clause, well, again, double jeopardy is actually found in the Fifth Amendment. So there is a clause in the Fifth Amendment that prevents an individual from being tried twice for the same crime in which he has been acquitted. But that, again, that was not found in the 14th Amendment. Due process clause, absolutely, that is what's found. States cannot deprive individuals of life, liberty, or property. And again, that's applied to the states. And the Supreme Court has used this 14th Amendment due process clause to apply the separate sections of the Bill of Rights and apply that to the states. And clearly, Santa Claus has not been used to apply the Bill of Rights to the states, because hate to burst the bubble here, but Santa Claus does not exist. So again, amendments 11 through 19, you want to go over these amendments. And again, there's nothing on the AP exam that says, you memorize these 19 amendments or memorize, these amendments here and there. But I'm using these amendments because to me, it's a very logical, chronological way to go over a lot of different concepts and tackle how the American system of government has handled changes to the needs of the population and how they've actually reflected that in a constitution that can only be changed by 2/3 vote of Congress and 3/4 ratification by the states. If you think about it, it's a very brilliant process, and something that has been going on for quite some time, and hopefully you get something out of it. Thank you for watching educator.com.